when the employees found a job, they will move on when someone pays them higher.
Yes.
But for an employer, if they get someone cheaper, they can't get rid of the expensive one. You know how unfair that can be, you know?
Auntie, my boss treats me like garbage. I want to sue my boss. But in the contract, It doesn't state that boss must be nice to me. It's not against any law.
Not necessarily.
Really?
Not necessarily. Because
Hello everybody, welcome back to another episode of BebelHR. You know, almost every week I will get this question from my followers. Auntie, my boss treats me like garbage. What can I do about it? I want to sue my boss. But before that, I always ask them, you got money or not? Is it expensive to sue your boss? What evidence do you have? Do you need a lawyer? And then even if you need a lawyer, is lawyer expensive? Can you afford a lawyer or not? So today is a very special episode. I am so lucky. It's like a windfall, okay? Today, I'm bringing you someone who has represented both employees and big corporations on complex workplace disputes. He has 3 decades of battling wrongful dismissal cases, and he's the guy companies call when things get messy. One of Malaysia's most respected employment and industrial relations lawyer, and he heads the Labour and Employment Law Firm of the Year in Malaysia, awarded by Asian Legal Business Malaysia Law Awards 2024. He is the senior partner at Tay Partners. We welcome Leonard Yeoh. You can tell how excited I am to have you here.
Thank you, AuntyHR. You know, I felt very privileged to be invited, and then paise, your introduction. But you know, if I can help your audiences, your fans, I will be more than happy to do that. Yeah.
So very basic things. What are the legal grounds for us to sue our boss in Malaysia?
Okay, generally for employees, what grounds you can sue the employer would also, from their perspective, need to know when is it that their employees could sue them, okay? So generally, the employers, they need to behave. You know, normally you only hear that employees need to behave in companies, right?
Yes.
But in actual fact, employers, they need to behave as well, because there are grounds that if they were not to behave, for example, how they treat the employees, that could actually open the floodgates of lawsuits against some companies. Just say a few grounds generally you could sue the company, or rather when the company faces claims against them, are generally when they dismiss someone because of misconduct, okay? Or they dismiss someone because of performance issue, when they feel that the particular employee, you know, is a poor performer, or in situations when there is a redundancy, may not be genuine redundancy, but the redundancy that some employees are not happy about it, and then because of how the company has actually acted on or the conduct before the termination as a result of the alleged redundancy, you could sue the company.
So technically speaking, the company has to go against a law. Like for example, redundancy. They must follow the redundancy process. They must be able to prove to court the retrenchment. There's a surplus of labor, for example.
Yes.
They cannot simply retrench you because I don't like your face.
They can't. They certainly
cannot. They must
cannot
have just cause or excuse.
Yes, that is a correct term. In fact, in Malaysia, there are 2 types of law. One is the statutes. I'm sure some of you have heard of Employment Act or the Industrial Relations Act, the IRA.
Yes.
These are statutes. These are laws passed in the parliament that guides the conduct of employer and employees. And then there is another set of law. This set of laws are judge or court created laws. These are common law. That means law derived from court decisions. So
case
laws. Yes, these are what we call common law, because in Malaysia we are governed under the common law jurisdiction. So we have laws created in courts, not just the parliament. So all that I've mentioned, the companies as well as the employees, they are guided by laws derived both from statutes, the Act of Parliament, as well as common law, that is court decisions that binds subsequent cases. Yeah.
So like in my intro just now, like my boss treat me like garbage. Like for example, they scream at me, they give me more work but don't add my salary. There is favoritism happening. It's not against any law. It's not against any statutes.
Not necessarily.
Really?
Not necessarily. Because I'm sure Auntie would have heard about constructive dismissal.
Yes, but it needs to have a direct breach to the root of the contract. In the contract, it doesn't state that boss must be nice to me.
But that's when laws came about. While it is not written, it can be implied through case laws. Not written in the contract, but it can be implied that employees and employers both have to behave themselves. It's just like contract does not say that the employee cannot speak vulgarity or even be rude to the bosses. Not in a contract. But you keep on doing it, it can amount to a breach.
They can take disciplinary action, right?
Correct. And likewise, for constructive dismissal, in your contract, you will not state CD or constructive dismissal as a ground that you can go and sue your boss or walk out and all those things. But through case laws, we know there are certain actions where the employer actually how they behave or how they react to a certain things or how they treat certain employees, it can amount to a breach that goes to the root. That's why you can claim constructive dismissal.
So for the benefit of the audience, Leonard, can you explain a little bit more what is constructive dismissal? I find that subject very hard to explain to my followers.
Okay.
I always tell them, boss scream at you does not amount to constructive dismissal.
Okay. Constructive dismissal is a breach, like you've mentioned, that goes to the root of the contract, or when the employer has the intention not to be bound by the contract. That means the conduct of the employer, the behavior is as if they do not want to be bound. That means it's like, your contract, there is express terms in the contract. There are also implied terms, implied terms to make sure that you act in good faith, duty of fidelity. All these are duties implied into a contract. But some employers, they think they are like gods, what they do is that they say, since I pay you salary, if I don't like you, I just cold storage you. I send you from a room, I take you out to next to the toilet, for example. I've got a case, this is a real case when the employer did not like a particular employee. So the person was from a department which is desk bound. When the employee is not happy with the employee is being sent to a warehouse.
Shit.
To be like almost like a security guard. So based on normal circumstances, do you not think that based on the terms that even impliedly, how an employer should be treating employees, that would be a breach?
I have a very simple question. I get this question all the time. What if my boss changed my job scope, but I did not agree to it?
Oh, then it depends whether it's reasonable to disagree or not. Take, for example, someone is an accountant or someone is a HR. Then suddenly, you just change the person's scope to become a business development manager, for example, and you don't have the skill set. You are an introvert, for example. And then you are being thrown, maybe on purpose by your boss, thrown into a job which requires, you can only excel as an extrovert in a business development role, that you end up cannot perform and then they get rid of you. Do you think it's fair? Yeah.
So let's debate on that a little.
Sure.
But what if times are bad, right? You are an accountant, yes, a senior member of the organization. But because times are bad, we don't have sales, all hands on deck. Everybody has to do BD, including the accountant. So we just tell you, everybody have to bring in 2 leads to company. If, let's say the accountant, I'm not a salesperson, I cannot do this, got grounds to dismiss me or not?
Again, it depends, Coming from a lawyer, I'll tell you, depends. Because you have to look at, other circumstances as well. If you look at the fact that the company is facing financial difficulty, there is no sales. If there's no sales, you don't need an accountant. If there's no sales, of course, HR also, the job also will be freer. You won't be recruiting people. However, if let's say it is not the situation where there's any financial difficulties, the company is doing well and so on, but suddenly because the boss did not like a particular person, just move, an introvert role to an extrovert role, that will be wrong. That could amount to like forcing the person to do something that the person cannot perform, only to find reason to get rid of the person. But based on the circumstances you told me, it would not be reasonable to reject also. Because if everyone takes up the task, not to victimize one or two person, but everyone, hey, come on, let's, the company's not doing well, let's all of us actually join force to bring in clients, then that is absolutely normal,
And it's reasonable.
Yeah, it's reasonable as well. So at the end of the day, if they ever bring action against the company, like you said, sue, there are of course many different forms you can sue the company, different grounds you can sue the company. If you want to sue because you got terminated, okay, it has to be reasonable to the extent we already mentioned about, when the employer terminates, it has to be with just cause or excuse, right?
That's right.
But one more thing you need to bear in mind is that in Malaysia, the industrial court is a court of equity and good conscience.
What does that mean?
Okay, equity and good conscience. Equity is like, it has to be actions that you do which are equitable. Equitable applies to both the employer as well as the employees. With good conscience, that means it has to be so reasonable that you cannot just cheat your way to say that, but this is the law, but this is my contract. That's why you know that despite what the contract says that you can actually terminate someone by giving notice, in actual fact, in Malaysia, you cannot just terminate people out of will. You cannot just say that I don't like your face, I terminate you, because in the court of equity and good conscience, you cannot do that.
You brought up a very good subject, because in almost all employment contract, they have that clause. They said that termination clause, that either party can serve each other a termination notice period. And they use that a lot, employers. They said, you already agree, we don't want you, we just serve you notice, but actually it cannot.
Yeah. This is something that many have actually debated on, because in that contract, it applies on paper to both. But in actual fact, in practice, only the employees use it and is validly used and cannot be challenged. That means I got 3 months notice, I resign, well and good. I just have to have a proper handover. You can't do anything to me. But the employer, if I don't like your face, I cannot give you 3 months notice.
Yes!
And then you think about it, when the employees found a job, they will move on when someone pays them higher.
Yes.
But for an employer, if they get someone cheaper, they can't get rid of the expensive. You know how unfair that can be or not?
I totally get it. Oh my God.
So sometimes we lawyers, we challenge the term court of equity and good conscience. So it's not very equitable to the company. If one day you're a boss, sometimes I try to explain to an employee who is not a boss. So I always tell this employee to say that, but somehow you also can be a boss, because at home you may have a maid, right? So if when you have a maid or a helper, I put it, a domestic helper, then you're also a boss. So how are you treating your domestic helper? Do you expect, when your domestic helper decides to go lazy, if he or she doesn't want to work or doesn't want to take care of your kids and all those things, and still demand the same pay, would you not get angry? Would you not have this urge to actually fire the person? You do it, right? So, but when it comes to you as an employee yourself, you generally say that, because employers are big, they should, be more caring towards us. I find a new job, I just jump, right?
There you go. So when you don't like your boss face, you can serve notice. But when boss doesn't like your face, they cannot serve you notice in return. Now, the next question. How much does a lawyer cost if I want to sue my boss?
Okay, again, as a lawyer, I'll tell you depends. Okay? Depends on what? Depends on, the
Let's
type
say
of lawyer.
constructive dismissal.
Okay. And there are actually options. Okay? There are options. You're talking about an employee seeking legal assistance or, legal help to go and sue the employer. Of course, there are, let me just put it simply, there are few situations you can sue your employer, okay? One of which is actually when you are terminated, for example, or dismissed, you go to the Industrial Relations Department, and then subsequently, if it is referred to the Industrial Court, then you actually sue for reinstatement, okay? Then if let's say you're owed salary, you're owed EPF, you owed maternity payouts and all those, you can go to the JTK, that is the Labour Tribunal. We call it Labour Court. That one, some employees actually do it themselves. You don't need a lawyer, okay? Then there is also what we call civil courts. Civil courts is where you feel that you don't want reinstatement, you want damages. I give you an example. For example, a high-ranking employee, it may be a CEO, and the CEO was promised some shares, some share options, but the company did not honor, a public listed company did not honor those share options. Then generally, you can't be asking for reinstatement, right? Neither can you sue for salaries and all those things under the Labour Court. So you actually go to the civil courts. It can be at the magistrate court, depending on the amount that you're suing, the sessions court, or the high court even, to sue the company. Those you will definitely require a lawyer. So in Labour Court, generally, you don't have to, but Industrial Court, you have options. You can engage a lawyer. You can engage unions, including MTUC.
Or MEF.
MEF is for the employers. Employers can also engage MEF and lawyers. But for civil courts, you can only engage lawyers. No one can represent you unless they're advocate and solicitors called to the bar with a practicing cert.
So if we go to JTK, most likely we don't need one.
You don't have to,
If go GPP, escalated to Industrial Court, is optional. But of course, you have a lawyer is better lah. They know it better, right?
Correct.
And if you go to civil, it has to be a lawyer.
You have to have a lawyer to represent you. Although you could still take your case on your own, that means self-representation, but that will be very dangerous because the courts may not give you the full indulgence. You still have to do what the lawyers do, file all the papers, file at the right court, file the right documents, meet the deadlines, do the legal submission. So if you're not a lawyer, it's almost like you try to treat someone like a bomo like that.
My God,
you need a doctor.
The bundle of documents. Because I'm a panel at IR Court. So whenever there's a case, right, they will send me the bundle of documents to look at. And I can see how many nights lawyers have to stay to prepare that bundle of documents.
And that is only I'm sure yours was an industrial court, right?
Yes.
So it's
I
actually
represent employer.
Correct. Perhaps likely a Section 20 case or something like that, right?
Yes, and union cases.
Yeah, and union cases. Those documents, yes, a lot. But you can imagine for lawyers, if you do cases like, some commercial litigation or even construction, it's 20 times more. So can you imagine the documents that we have to face actually?
That's why you keep AA very happy or paper one.
Yeah. Are you supposed to promote a brand? I'm just kidding.
No. But who knows? Anyway, so ultimately, let's say we give a hypothetical situation. It has escalated to Industrial Court. And I choose to hire a lawyer. So how much money I need to prepare?
Again, my usual answer depends. Okay, so there are many options available. Of course, some law firms will charge a fixed fee. So it's upfront, you can say, this is amount I'm willing to pay, the only amount that I can afford, that will be your fee. So it's a fixed fee.
Is there a minimum?
Generally in law, there's no such thing as minimum. There's no such thing as minimum, but it's up to the law firm. You may even do it for free. The lawyers may even do it for free if they want to. For a friend, they do it for free just to cover my disbursements when I need to, take a Grab or whatever, you pay for that. And maybe I need to photocopy things, you pay for me. I don't need to charge you if it's a friend. So that's why there's no minimum, there's no bottom, no floor sort of amount of fee for lawyers. But there are other options. Apart from fixed fee, there's always the other option of cap fees. So the cap fees is I may even charge you my charge out rates, how much it costs my time in an hour or how much the team's time in an hour I will charge you. But up to a limit, that's called a cap fee.
Typically, what is a market rate per hour? Typically.
All depends. The junior lawyers could be between 300 to 500,
Per
600
hour.
per hour. The more senior one, 1,200, 1,500, 1,800, up to 2,000, 2,000 plus. Yeah.
Per hour.
Per hour, yeah.
And how do we evaluate how much hour a lawyer spend on a case?
They have to be honest about it, lor. So we have
It's
to
all
do
based on trust.
correct.
lah.
So we have to do the timesheets and show how many hours you spend on something. You can't cheat your clients by having a call with a client for 5 minutes, but then you put your timesheet half an hour. That would be very
There is
dishonest.
timesheet?
Yeah, we actually produce timesheets if we do a time cost.
Shit,
Yes.
so long I haven't heard that word timesheet.
Yeah, we for charge out rates that we charge time costs, we actually have to do timesheets for our clients. So that one is one option. That one is called strictly time cost based, and then with a cap and then fixed fee. Then
That means there's a maximum.
maximum
is it?
law. It's just like for this industrial court case, the cap is actually 50,000. I'm just giving an example. And then your time cost may reach until 80,000, but I can only charge
Charge you
50,000 because
50K,
there's a cap.
okay.
But if I spend time for 40,000, then I can only charge you 40,000 because it's based on time spent, but there is a cap over it. So some foreign multinationals, they prefer such arrangement, not strictly time cost, some time cost plus a cap, and then some will still go back to the traditional fixed. Then there's a fourth option.
Oh,
Okay, the fourth option, some lawyers initially think that is prohibited. That is the contingency arrangement, which are actually prohibited under our governing, our legal
is
profession
it only
ethics.
in Malaysia?
Some countries also, but some countries are strictly you can arrange for contingency, like the US and all those things. You can.
So contingency means
No fee.
nothing upfront unless there is a outcome, right?
There's an outcome. You get the money, then you
Outcome-based.
get a cut away. That is prohibited. But what is not prohibited that a lot of lawyers do not know that has been decided in the highest court of the land to say is what is we call a success fee. Okay, success fee is where you have a fee, you can have an agreed fee, and this agreed fee is actually agreed upfront, and then you pay. But there's an element of success basis there.
Okay.
That means if you win, you get the money. In addition to the fee that you've agreed, you get some bonus. So those are called success fee. And some people arrange for that, especially for lawyers who represent the employees. So to make it is an easier landing for them. When they want to start off, they don't have money, they just been fired and all. Then they say, okay, maybe we can arrange. You pay me a fee, not so high, but if I do win the case for you, then I'll get a cut out of it. Those are success fee. Yeah.
Every time I watch TV, they like to do this pro bono. What does it really mean?
Pro bono is like no fee, like I said, do it free.
But you said it's prohibited.
No, that one is contingency fees are prohibited. That means no fee, no success, no fee. That means only when you win, you get the money, then you get fee.
Why do they prohibit that? For me, it's fair, what? You got result only, I pay lah. No result, I don't pay
Okay,
lah.
on paper, it appears fair. But I tell you one example that my opponent, of course, I had many cases. There are some opponents perhaps may still be practicing this contingency, okay? Or maybe some variation of success fee, I do not know. But halfway through the trial, when they couldn't produce certain evidence, or halfway through the trial, I could produce more evidence, when the lawyer on such arrangement feels that, I may even lose the case, I might as well just drop out. Then
Shit,
they just drop out. They just drop out.
So
Why?
irresponsible.
You can't say that because, like what you said, you think it is good if they win, then only they get rewarded, right? Now that they know that the end result is more likely they lose than win, then why should they not drop out? So they'll just drop out. So that's why it's prohibited, because it will be a disservice to clients if lawyers just do the arrangement that I don't get paid a single cent if I lose, but no one can control the evidence throughout, or halfway through the trial, their own witness do a bad job. But before they call the next witness, they feel that, I think I'm done with already this case. Then they won't turn up. And some of them will just try to discharge themselves. And then it will leave their client, their employee, they are left hanging. But then some other friends will say, but what to do? You never pay people a single cent. People also need to eat. People also need to take baths. People also need to print things. There are such arrangements, but this arrangement, to me, is dangerous. To me, I can accept which is allowed a success fee based on, you still need to be paid, just that you got incentive when you win. At least that is more healthy than strictly no fees until you win the case. That is contingency that the law of the land prohibits lawyers from doing that. Yeah.
Sometimes I hear people say, they charge you last drawn. What does that mean?
That should amount to a success fee arrangement. So the last drawn is maybe an arrangement between the lawyer and the employee to say that your fee until the end of the trial will be your last drawn salary. Could be 10, could be 20, could be 30. That would be the fee. But over and above that, the success is that if I'm able to collect money from you, for you, I win the case and collect the money for you, then I will get a cut out of it. So over and above the last drawn. So that is okay. That is not contingency because you have an agreed fee, but you got some incentive for winning the case. Yeah.
So typically, what is the right cut? Like in property, they will say like between agent and what is 50-50, that kind of thing.
In the market that I know, it can go as low as 15, 20, 25 to 30% cut of the winning sum.
15 is really low.
Yeah, 15 is really low. No, it also depends. Although it may sound low, but if let's say, your payout is $1 million, so 150,000 is not low. So those typically, if you get $1 million, your salary must be 30,000-40,000. So your last round also 30,000-40,000 plus the 150,000. That is certainly not low.
Yeah, I can see some law cases they awarded like in millions.
In millions. So if you get 15% out of it, it's not low.
Yes, that's right. That would be in 6 figures.
Correct.
Okay.
You will certainly be in 6 figures.
So Leonard, what would your advice be? At what stage should I bring in a lawyer?
Again, it depends on your budget. If you at the end of the day, you will engage a lawyer. To me, since you're already going to engage a lawyer, engage them as early as possible. Why? Perhaps because of the fee arrangement, it would have been the same fee anyway. So why engage later when you got the services of a professional assistant? You might as well get the lawyer as early as when you have trouble with the company. Even in replying letters, even in drafting, or if you want to claim constructive dismissal, the letter to claim constructive dismissal, it ought to be drafted after the lawyers have reviewed. So it's as early.
All this show cause letter, if I really want to hire a lawyer, how much would a lawyer typically charge me to reply a show cause letter?
Again, depends on the
length.
The fee arrangement.
Okay.
Fixed fee.
Then a
success fee, a cap fee, time cost, or success fee. It depends. I rule out contingency because I don't condone it and it's illegal. Okay. So if it is a fixed fee, it can be, if it is a simple show cause, it can be 1,000, 1,500 or 2,000. But if it's a really lengthy one involving a CEO or managing director, it can cost up to 5,000 to 8,000, just to reply, because you need to look through a lot of documents, you need to compile documents, and some reply to the show cause includes bundle of documents in an annexure and all those things. Those may almost like doing a court case already. So may even raise up to 15,000, 20,000. Yeah.
So some of the followers come to me and they say they got no money. I said you should try out MTUC. What do you think about it? Like I know they are not trained lawyers.
Yeah, they're not trained lawyers, but they are pretty experienced because some of them have worked in the industrial relations department. Yes. Some of them have worked in the labor, the GTK and all this. So many of them are retirees, and some of them are, they just are interested, to fight for the cause of employees. So I wouldn't say it's a bad thing, but of course there are differences lah. It's just like when you have a health issue, right? There's also option. You can go to TCM, you can go to doctor, and some even go to BOMO. So there are actually many options. But for MTUC, most of them are not legally qualified. They are not advocate and solicitors. And some of them, actually some has LLB, as in a Bachelor of Laws degree. Some, they don't even have a law degree. So they are just like, previously doing finance or doing HR itself, or with a HR diploma and all. but they can represent. They are legally allowed to represent employees. Okay, the difference is this: because they are not lawyers, if the case is too technical, where you need very technical legal submission, or the legal point is a bit novel, that means never been argued before, or it's fairly new, or the law just changed in Parliament, or even the federal court has just decided a new case, then a person who is not a trained lawyer, while they may have heard, may even read, but to decipher, to understand, to explore, and to dissect, they're not able to do like a lawyer. So, like I said, a plain case, straightforward, maybe they can be just as helpful, but slightly more complex. So I will rate it if your salary is up to a certain mark, don't be too stingy lah. You can
When you
hire
say that mark, what is that mark?
I don't know. On average, if you can earn, let's say, between 8,000 and above, 15,000, up to 20, 30, I think if you can afford a lawyer, just go for a lawyer lah. But if you are slightly on the lower range, right, I believe MTUC can do a good job if it is a straightforward case. No problem.
I have a last question. Now, we don't talk about industrial case. Let's talk about rescinding offer.
Rescinding an offer.
That is a civil case, right?
Rescinding an offer as in...
Rescind offer for the benefit of the audience would be,
Okay.
I offer you a job, contract signed and written already. Last minute, I say, I don't want to hire you. I want to U-turn the offer. Then what does the candidate do? I don't know. They are not an employee yet.
Yeah. Generally, my advice is that you will have to go to the civil courts.
Which means you must hire a lawyer.
You must hire a lawyer. You go to the civil courts, but actually the rights that you have also, it has to be like a breach of a contract because you have entered into a contract. There's offer and acceptance, and then there is also consideration. Why? Because you actually forego some other offers you sign, but before you start, they actually rescinded it, right? Then you sue the company for breach of contract. But of course, you need to be able to prove damages. If you have got no loss, you go to civil courts, you get nothing. So you need to know.
How do I prove damages? Like I already resigned from my job.
Yeah, you resign from your job. You have got monthly commitments, and you rejected other offers. And other offers I would have started. So for those salaries I would have earned, but for the rescission, then I would actually group that together as losses I've suffered. Then you sue for damages. Yeah.
At what salary you think is worth it to go after that?
Again, actually it's very subjective lah.
Yes.
You know, some people even 2,000-3,000 also because the family is rich so they sue lah.
Okay.
And those people earning 20,000 very stingy also, they may not want to do it, you see. Yeah.
Then I want to know, at least if I decided to, let's say I come to Tay and Partner to hire a lawyer to represent me, right? How much I have to be prepared, at least a minimum amount? 10K?
Again, it depends on the arrangement, fixed fee, time cost, cap fee, or
Let's say the
element of success fee.
most economical situation.
A last drawn salary will be quite reasonable.
The last drawn, typically I have to be ready with 1 month.
At least a last drawn.
At least my 1 month salary.
That will be the fee that you're prepared to pay. And then at least if let's say, there is no success, then that is whatever you pay. But you still have to pay for whatever disbursements are. If you need to photocopy, you need to pay the lawyers to go to courts. They have to, the lawyers will claim.
How much is all these disbursements?
Maybe add a few thousand. So it depends. For example, if your salary is 10,000, you must be prepared with 10,000, maybe add another, 4,000-5,000 for disbursements and tax. I think you can start the case really actually. Yeah. If the lawyer or myself, if I accept the case for the, the lowest range of success fee, okay, then that will be it. But of course, typically if that is not the arrangement, the fixed fee generally will be higher. The fixed fee will be higher for the entire trial process. It should be higher than 10,000.
So that's why we try to settle out of court, right?
It's not a bad idea if you can settle out of court. You can.
But lawyers also help to negotiate to settle out.
Of course, and of course you need to pay the lawyer some fee to do that. Again, for that also, you got these 4 options. And if you pay a lawyer to do your settlement, then I tell you, those success fee will be more lucrative for the lawyers. Because you don't have to do much, right? Yeah, and then success, you get a cut out of it. Yeah.
That's right. Thank you so much, Leonard, for coming. Before I let you go, can you just share with the audience one ajaran sesat that you can share with us that we need to prepare? What we can do to protect ourselves?
Okay, of course, if you ask me a straight answer like that, I'll tell you, just behave yourself. Okay, but okay. Back to business. In actual fact, as an employee, if you potentially see that you may have a case against the company, then be prepared. You know, you don't delete your messages, and if you do copy, if you do copy yourself, if not, then if you reply, for example, your show cause, obviously you need to get your documents ready. Because at the end of the day, when it reaches the court, you need to file what we call a bundle of documents to support your case.
So trick will be I BCC my personal email.
You have to be very careful.
Why?
You don't always BCC things because BCC, some employers will threaten you for, breach of confidentiality.
Oh,
you
but
know
how
what I mean?
I keep evidence then?
You see, this is like chicken and egg lah. If let's say you don't have any documents, you may even fail in your case.
Okay.
Because discovery process is a bit difficult in the industrial court as compared to the civil courts.
Okay.
So if you don't have documents, it could even be a non-starter if the company do not want to produce it.
So how do I gather evidence?
So you actually do photocopy. You do photocopy or print out the documents.
Print out and keep hard copy
Actually, if I speak on behalf of the employees, you shouldn't even be using the company's photocopy machine. Okay.
But I don't think they go to that extent. They can trace.
Yeah, maybe soft copy. So if you really want to print the soft copy that you keep, and these are evidence that will support your case, and then you bring this soft copy and photocopy outside. That will be the right thing to do. That is something that I will advise the employees. Yeah.
Very good, ajaran sesat. So we save the soft copy and print it outside.
But I wouldn't advise people to go and, threaten the company by, keeping a lot of soft copy of confidential information. That is wrong. They can be sued by the company also.
Also can be counter-sued.
Yeah. Then from my experience, there are companies will go to the extent that they know that the employment case, an IR case is going to be filed against them. They, in turn, will go to the civil courts and file an injunction against the employee or the ex-employee because they allege that there's a breach of confidential information, that there's some trade secrets being taken by the employee. Then they file an injunction in court. Then you can imagine the fee that you need to pay your lawyers to defend an injunction will be much more than what you would spend in an industrial court case. So be careful. Be careful when you actually gather and collate documents. Don't do illegal things. Because memang, if let's say you take confidential information, that is wrong. And the company can actually take civil action against you.
There you go. Thank you so much for coming today.
Thank you for inviting me.
If you guys have any comments, you can put your question in the comments below. Please remember to like, share, and subscribe. Bye!